HYBE's Gwarosa death case closed. Result confuses K-pop fans. Seji's exclusive report detailed the result of the case. South Korea's Ministry of Employment and Labor has now concluded that there were no violations of the law from HYBE, which was alleged to have swept under the rug a workplace accident that resulted in death. On December 21, 2024, KST, the Seoul Western District Office of the Seoul Regional Employment and Labor Office recently wrapped up its investigation into allegations of HYBE's covering up an employee's Gwarosa death from overwork. It issued an official response to the complaint case filed stating, "It is difficult to consider the case a violation of the law and close the case." The result was, reportedly, communicated to HYBE on December 17. The allegation that HYBE covered up a Gwarosa was first brought to public attention during a National Assembly audit back in October. Auditors' new CEO, Joo Kim, was questioned about the 2022 case, where an employee at HYBE collapsed at work and later passed away, said to be due to being overworked. A complaint based on the allegation was filed with the Labor Office, prompting an investigation into potential violations of the Industrial Safety and Health Act. National Assembly member. We received a tip-off that in 2022, an employee of HYBE had fainted in the office and was brought to the hospital where they passed away. Is that true? Joo Kim. Yes, from what I know, in September 2022, an employee went to the break room around 5 p.m., saying they would take a rest. Unfortunately, they passed out, and we found them in the break room and moved them to the hospital. They passed away a few days later due to their personal illness. It's an unfortunate case. National Assembly member. Personal illness, you say? Well, all of the officials here think that it is overwork. Back then, HYBE was expanding its label system and workers had to take care of multiple artists at the same time, going for overseas schedules at the same time. There were many cases like this in your workers where they had to work all day and all night. I checked with the Korea Workers' Welfare Organization and there was no application for accidental workplace incidents. You claim that it was due to their personal illness, but we think you should have checked on the problem, and we deem it due to overwork. We want to ask if the company tried to conceal the death through overwork. A Labor Office official explained. In this case, no industrial accident claim was filed with the Korea Workers' Compensation and Welfare Service, and the determination of a work-related health complication was not confirmed, leading to the conclusion that it is difficult to regard this as a legal violation. In other words, since the bereaved family did not file a claim for a workplace accident, it was not possible to assess whether the death was due to overwork. Additionally, the investigation looked into whether it was a workplace accident, but also whether the accident was actively covered up. The ministry concluded that concealment cannot be established if the bereaved family does not view the case as a workplace accident. Following Seji's exclusive report on the result of the case, K-pop fans have taken to online communities expressing disappointment, but more so, confusion at the conclusion reached, as well as the logic behind the conclusion. As this conclusion will be reflected in the review process for the potential withdrawal of HYBE's designation as a leading company, attention is focused on the final outcome of the withdrawal decision.